All right, State, you wish to make an opening statement?
Yes, Your Honor. Pain, suffering, fear of a 9-year-old little girl fighting for her life the moments before she died. These are some of the things that we will discuss this morning as we enter the stage, the sentencing stage, the second phase of this case. There are unfortunate things that you are going to have to hear, and you did not hear this testimony during the guilt phase because it wasn't relevant at that time. But these things are most certainly relevant when you are determining whether or not the defendant should serve life in prison or be sentenced to death. The state has filed a notice of 3 aggravators, 3 aggravating factors that we will prove to you beyond a reasonable doubt and lead you to the final sentence of death. One aggravating factor is that the victim is a person less than 12 years old. The second aggravating factor is that during the commission of the first-degree murder, the defendant was engaged in capital sexual battery. And the third aggravating factor is that the first-degree murder was especially heinous, atrocious, and cruel, which is sometimes referred to as HAC. Let's talk about the first 2 that I mentioned. By your verdict yesterday, you have already determined that the state has proven those 2 aggravating factors beyond a reasonable doubt. You already determined, based upon your conviction of the capital sexual battery, that Felicia Williams was a person less than 12 years of age. That means Granville Ritchie is automatically death eligible. Also, by your verdict yesterday, by finding him guilty of first-degree felony murder, with the underlying crime being the capital sexual battery, you have determined that the state has proven beyond a reasonable doubt that aggravating factor. That during the commission of that first-degree murder, he was engaged in capital sexual battery. So this morning, you will be left with hearing testimony, again, from Dr. Downs. He is flying and has flown down here from Georgia again, and he will be presenting testimony specifically with regards to HAC. And at the conclusion of his testimony, the state again will have proven beyond a reasonable doubt that aggravating factor. That Felicia Williams suffered, the pain she endured as she was being sexually battered and strangled, the mental anguish that a 9-year-old was going through when she was being attacked by that man, which you have already determined. The anxiety and what she felt the moment she took her last breath. The state would submit to you that at the conclusion of Dr. Downs' testimony, HAC will have been proven to you beyond a reasonable doubt. The judge briefly discussed the 5 steps that you will need to go through in order to come to your ultimate decision. They were previously discussed with you a little bit during jury selection. The first step is that whether or not the state has proven the 3 aggravating factors or any one of the aggravating factors beyond a reasonable doubt. But again, you have already determined by your verdict that the state has proved 2 of the 3 aggravating factors beyond a reasonable doubt. You will then determine whether or not these aggravating factors are sufficient for the imposition of death. Are they weighty enough? Do they carry enough weight for the defendant to be sentenced to death? The rape and murder of a 9-year-old girl in the way that she was murdered what she endured in those last moments, knowing of her impending death, those are 3 very strong aggravators. The third step will be to determine whether or not any mitigating circumstances were proven not beyond a reasonable doubt, but beyond a greater weight of the evidence. And I anticipate that you will hear some mitigating circumstances presented in this case. I anticipate that you will observe a video that's been prepared several months ago containing some family members and friends of the defendant who live in Jamaica. It will be presented to you in the form of a video. These people will not walk into this courtroom and raise their right hand and sit in that chair before you and be subjected to cross-examination by the state. I anticipate that you will also hear from a neuropsychologist, a Dr. Eisenstein. And I also anticipate that you'll hear from not a radiologist, but a neuropsychologist who will talk to you about a PET scan that was done. They will tell you that the defendant suffers from cognitive impairment and what that means. After that, I anticipate that you will hear from 2 rebuttal witnesses, Dr. Lazaro, who is also a medical doctor, a psychiatrist, who will tell you that the defendant suffers from no cognitive impairment. And you will also, in fact, hear from Dr. Holder, who is, in fact, a radiologist, who will tell you that these PET scans look very pretty, they have nice colors, but they are to be used in no way in diagnosing cognitive impairment. But the third step that you must look at is whether or not these mitigating circumstances have been proven by greater weight of the evidence. The fourth step in this process will be for you to determine whether or not the strong aggravating factors outweigh the mitigating circumstances. And the fifth and final step is whether or not the defendant should be sentenced to life or death. This is going to be a much shorter trial than you have sat through during this guilt phase. It doesn't mean that it's any less important. And we know, in conclusion, on behalf of the state, that you have sat through 2.5 weeks of testimony, listening to us speak, and it hasn't been easy. And your job is almost done, but it's not yet done. The state is confident that at the conclusion of this sentencing phase, you will determine that the state has proven all 3 aggravating factors beyond a reasonable doubt, that these strong aggravating factors most certainly are sufficient for the imposition of death. These 3 aggravating factors outweigh any mitigating circumstances, and that the defendant deserves death. Thank you.